Good evening and welcome to Unfiltered. My name is Sizwe Mpofu Walsh. The Road Accident Fund exists to protect South African road users from accidents. But it's been mired in a series of controversies, ranging from court cases to its accounting standards, and most recently, there was a fiery meeting in the Standing Committee on Public Accounts surrounding the Road Accident Fund. Tonight, we're going to delve into these questions and go a bit deeper into what is surrounding these controversies with the CEO of the Road Accident Fund, Mr. Collins Letswalo. Mr. Letswalo will join us to delve into these questions, and we will engage on a series of discussions with him. But before we do that, we'd like to give you some background and context, so let's have a look at this insert.
It's our outlook that the board is not fit for purpose. And the minister, in exercising her rights in terms of the Act, please advise her. Colleagues, I'm proposing that she submit to us a report as to why the board, of course, is not appointed as it should be, in the manner that it should.
A parliamentary committee, SCOPA, showing they've reached the end of their patience.
With all due respect, DM, in the ministry, I think you are failing us.
They're demanding tough action against the Road Accident Fund's leadership. Recalcitrant management, a damning special investigating unit investigation running into hundreds of millions of rands, and thousands of motor vehicle accident claimants facing payment delays, while management insisted on endless court cases costing further losses to the taxpayer.
In 2020, the International Public Sector Accounting Standard Board issued a new standard for social benefit, as RAF as a social benefit. We use this in line with GRAP 3 to develop our new accounting policy in line with that. So that's the only difference we have with the AG. Nothing much, nothing less. Our view is that GRAP 3 allows us the right to do so.
Until recently, the bone of contention has been the fund's insistence on using different auditing standards, adamant that it provides a social service and can therefore not be audited as an insurance fund. All this in dispute of the Auditor General and other stakeholders' advice.
Because the bottom line is that nothing, absolutely nothing, zilch, zero, nada, luto, has changed from September 22 to date. In fact, what we have is a vanity legal process of epic proportions. It's a legal expedition anchored in recalcitrance, anchored in arrogance, and I reiterate the point that I made, that everybody else is wrong and that you are right. You are an island of correctness. Everybody else is wrong. It has become a fishing expedition at the expense of the taxpayer.
The Auditor General argues that the changes in accounting policy undertaken by the RAF in April 2021 understated its liabilities by 300 billion, particularly with how it dealt with insurance contracts. But the biggest elephant in the room is the ongoing investigation by the Special Investigation Unit, which implicates legal firms and medical service providers providing services in relation to vehicle accident claims, some of whom have admitted to fraud, submitting double claims and enriching themselves at the expense of the taxpayer and victims of motor vehicle accidents. After serious allegations of maladministrations, malpractice and corruption at the fund, President Cyril Ramaphosa stepped in 2021 and tasked the Special Investigating Unit to help uncover the underlying issues. The Road Accident Fund was established in 1997 to provide compulsory cover to all users on South African roads, including foreigners, against injuries sustained or death arising from accidents involving motor vehicles. While concerns about delayed payments have always dogged the fund, recent revelations about the extent of fraud associated with it suggests an organization that lacks proper oversight over its finances and a weak system that can easily be defrauded. Last week, the fund dropped the case after spending an exorbitant amount of taxpayers' money to fight what seemed like a losing battle from the start.
The situation at the RAF, as at last week's SCOPA meeting, is so dire that Parliament is calling for the board of the RAF, the CEO, and the leadership of the RAF to rather resign and find role players that's willing to execute the mandate of the Road Accident Fund. So, as a general context, there are many problems, but there are many solutions. But you need a willing RAF leadership to focus on the solutions. And they have clearly demonstrated no interest in finding solutions.
With South African roads ranked as the third most dangerous in the world, it is inevitable that accidents will continue, leaving many injured or killed. While thousands of victims await their payments, with many more being rolled over from previous years, should the board and management of the Road Accident Fund be fired. For Unfiltered, I'm Skangiwe Mtiani.
Mr. Letswalo, CEO of the Road Accident Fund, thank you for joining us.
Thank you very much, and thanks very much to the viewers at home.
A fiery meeting at SCOPA. Before we move on to some of the substance of that, there were some outstanding questions from that committee meeting that we can now get some clarity on. At that meeting, you and your board chair, Ms. Msibi, promised to provide a report by the 28th of April. Was that report provided? Has it been provided yet?
Absolutely.
You can confirm?
With what we agreed with the minister we are going to do, that's what we did.
And in terms of the committee, there were a number of calls for the resignation of the board, even some intimations about your own resignation. Has anything happened on that front? Are there any resignations expected, or are you quite comfortable with both the position of the board and yourself?
What are we resigning for?
Well, we're going to get into that.
Yeah, but I mean,
today.
there's nothing to resign for. I don't. Yeah, but I don't even think that that's what the SCOPA said. SCOPA said the minister must exercise her rights in terms of the law.
Well, the chairperson of
clear.
SCOPA intimated that he had lost confidence in the board, which we just saw in that insert. And then there's the chairperson of the Auditor General's Committee, who actually said he thinks the board should resign. So there were some strong statements about resignation at that committee.
They said they lost confidence. We don't know why they lost the confidence. I mean, it's not very clear. When you go in front of people and you want to raise issues, they don't allow you to do so. You are muzzled. What is expected? I mean, you would have seen every question that was asked was answered properly. All we were told was that, well, you don't listen to us. But then the listening to you must also be based in law. So which law is this one that people raise? And I think it's unfair for the management and the board to be treated in that way. You call people to a forum, you allow them to tell South Africans what the issue is. And I think it is very clear that there are things that are being said, I mean, even in the insert, that are so far away from the truth. And we are going to unfilter that today, I hope.
Well,
absolutely.
Let's
I think that's what is important for me.
No,
I think,
absolutely. Let's get to that, because there were some calls for resignation. I mean, that can't be disputed.
There was a call for firing of people, not resignation.
Resignation. But let's leave that to one side, because that's a matter of public record.
Yes.
In terms of this question of the accounting standard and the accounting policy, this seems to be the big bone of contention.
Yeah.
Where do we stand on that? You adopted this new accounting policy that went to court. It's no longer in court now, but that seems to be the key area of disagreement in Parliament. Are you still standing by the new policy and the new accounting standard?
Absolutely.
And why do you still stand by this standard when, number one, every member of that committee, it's very hard to unite South African politicians right now, but you've managed to do that. Every member of that committee thinks the standard is inappropriate. The Accounting Standards Board thinks it's inappropriate. The National Treasury thinks it's inappropriate. So the only group, apart from your consultants, that seems to think it's appropriate is the Road Accident Fund. And surely at some point one needs to appreciate that the rest of the government just doesn't think so.
Your name is not Sizwe. And I'm telling you so. So tomorrow change your name. That's what we've been told. And I mean, I'm making this because I'm saying to you, at no point are you hearing the rationale of why people are saying we are wrong. Okay, so this starts, this thing, I think you must start here, okay? People are going to say, well, they changed the accounting standard, what happened and all that. Understand that management are preparers of financial statements. In there, we must give an undertaking that we fairly represent the financials of an entity as management. Then, of course, there is an accounting policy that is derived. And I need you to focus on this accounting policy because I'm going to tell you why we have an accounting policy and why we don't just simply apply an assessed standard. Then, of course, we are going to say where did we start and where we are and why we are here, because it's going to be very important. You see, I can scream the loudest and tell you are not Sizwe. You are Sizwe, and that is a fact, okay? The truth, the nice thing about the truth is that it never changes. Facts can change and everything, and you're going to see this with this. So I'm approached in 2019, having been at the Department of Transport for, I think 11 years at the time, as a CFO. A CFO is a chief financial officer, someone who prepares financials every day. So I prepare financials. I have went in, presented financials in Parliament. I'm told, go there is a problem. What is the biggest problem we have? Is that this entity is collapsing. It is actually looking for a bailout, like most SOEs do. And the sixth administration wants to do something about it.
So I hear you there, Mr.
Yes.
Letswalo, and
Yes.
I understand the importance of the background.
Yes.
But my question,
Yes.
once all the background, let's assume you've looked at this, you've scrutinized this. Once you've gone through that process,
Yes.
the Auditor General also knows that. They also scrutinize financials all the time. National Treasury surely knows its stuff, unless you're saying they don't look at the financials. Accounting Standards Board also knows.
You allow me to take you through this because Sizwe, it's problematic, and I'll tell you why it's problematic.
But can you also address my question as well? Because
which is I'm telling you where the difference is.
Yes,
because I mean you must understand where we come from.
Why are they wrong? Why are they wrong today?
Of course, you must arrive there.
You
want to get to that point. Okay, let's get to that point. So when and this is the accounting thing, and it's a technical aspect. Okay, sure. So if you have not done properly accounting one, you won't understand it. You have not done accounting two. So I'm going to try and explain it like I would explain it to my 9-year-old daughter.
Explain it to the public.
So let me explain it this way.
Whom you're accounting.
So ordinarily, when you prepare financials, what you do, you go into your standards. You are preparers. So your standards, you look at the horizon. What has changed this year? What has changed this year? You need to say, I am presenting financials that are fair, gives you a fair representation, everything that you need to do, which is something that you give an undertaking about in the financials. Okay? So what happens? We look at this thing. It's a problem that started in 2013-14. What had happened there was that RAF was told, okay, there was a letter that they received from the ASB. This letter says you must consider using IFRS 4.
Sure, which is an accounting
standard in developing your accounting policy. Why do you use IFRS 4? There is no standard for social benefits in South Africa. It was not there in 2008 when the GRAP framework started. It is not here today.
Sure.
So we don't have it.
So why do you decide to change away from IFRS 4?
But that's
the key question.
That's the point.
Because that has massive financial implications.
Of course, it's going to have massive financial implications, whether positive or negative or whatever.
Sure.
Here's the part. You are told you must use this IFRS 4 because IFRS 4 is accounting for insurance contracts. There is no such a thing at RAF called insurance contract. It doesn't exist.
Your website seems to suggest that one of the things you do is you insure road users against their accidents.
There is no such a thing.
It's on your website.
No, but let's go to the act.
Uses the word insurance.
Let's go to the act.
So your website is wrong.
So it might be wrong.
Okay. Well,
there is social insurance as well. You must understand that there is insurance, there is social insurance, there is commercial insurance, and there's all those things. So social insurance is like a social security fund, which is what RAF is. We arrive there. The reason why you are using IFRS 4 is because you couldn't find a GRAP standard. Why don't you ask people, why are you not using GRAP? Because you are in GRAP. GRAP standard is generally recognized accounting principles.
Well, the reason
yes.
some will say is that, look, at the end of the day,
yes.
when you changed accounting standards,
yes.
you magically wiped off this massive debt of 300 billion. And
that never existed.
Suddenly, your debt is now 10% of that. So to say, well, it's just about the way we account.
No.
Was it not trying to use an accounting loophole to make sure you could go to the capital markets? And just let me finish the question.
Yeah.
Make sure you could go to the capital markets,
yes.
hide that there really is 300 billion,
yes.
and actually say, no, there's only 30
and
billion. That was the idea.
And benefit what?
Well, to be able to get loans, to be able to go to the capital markets
Did
and
we
say,
get loans?
well, the fact that you haven't is also sad.
No, it's not sad at all.
The question
it's a decision.
The question is, did you not try to use clever accounting loopholes to actually obscure the true extent of RAF's debt?
No, but you see, Sizwe, this is unfiltered, and I think you said to me we must talk to the part where it's unfiltered.
Absolutely.
I go back and I try to give you a background. You refuse the background. You now are telling me what people are saying. What you are saying there, that we were doing this for purposes of the thing, is what people say. It's not the truth. Okay? So here's the part. Let me tell South Africans.
Yeah.
So we arrive at RAF. We are told there is 319 billion liability. Now listen to me. I'm saying a liability.
We agree my name is Caesar.
We are told, yes. We are told there is a 319 billion actuarial liability.
Sure.
How do you measure an actuarial liability? If you were an insurer, you have got a contract. You are forced, when something happens, for you to cover it. Okay?
Sure.
You are also fully funded. What does fully funded means? It means when you collect the money, you collect it as a premium, which is risk adjusted. So when the risk increases, the premium always does increase. So that's what happens in insurance. RAF is not an insurance. That's a fact. Okay? So where do you get the part that RAF is not an insurance?
Well, firstly,
yes.
Look, we're going to carry this on. We have to pay the bills like you. So let's
I hope you are paying the bills and you are going to allow me to finish what I said.
Absolutely.
Okay,
we've got all night.
That's
thank you for keeping with us. Stay tuned and just consider whether my name has changed in this advertising break as well. Welcome back to Unfiltered. We're in conversation with Mr. Collins Litswalo, who's the CEO of the Road Accident Fund. Before we went to the break, we were in discussion about this accounting standard and the policy. And the question, I guess, was what motivated this change?
Yes.
And I'd put it to you that some people said it was to try and obscure the size of the liabilities at your...
Firstly, I must say we have got nothing to gain by doing that, because I don't think what would I achieve out of that. But the issue that I was raising is that there is no accounting for social benefits, a GRAP standard in South Africa. So when there is no such a standard, you go through a process of developing your accounting policy. So you go through a thing called GRAP 3. GRAP 3, paragraph 13 says to you, you can only change your accounting policy on two bases. One is that if it's the requirement of a standard of GRAP. Two is if it ends up in reflecting a correct position from what you see. So it's a proper emphasis on the liability. Now, what then happens is we then go to what is called, I think it's paragraph 8 of GRAP 3. That says to you, when you do this, you develop what is called an accounting policy. It says management must use its judgment. So that's management that must use its judgment. That's the GRAP standard. That's what it says. The second one then says, this is the process you follow. Then it says to you, you look, if there is no GRAP standard that exists, you are going to develop your accounting policy, but you are going to use standards of other standard setters. Then it then says to you, when you look at the standard setters, you are going to look at in descending order, meaning you start with the first one, which is the International Public Sector Accounting Standards Board.
So, okay? And I appreciate the technical detail here, but water has passed under the bridge on that, to the extent that the Accounting Standards Board has said this new standard that you used is inappropriate. The Standing Committee on Public Accounts has agreed with them.
That is not
true. The AG has also said, it is true.
No,
it is true. The AG has also said that standard is inappropriate, followed by the National Treasury.
It is not true.
So, okay, but if that's the case, right, you are prepared to argue this question all the way to court because you were in a dispute with the AG about whether this should be used. And you withdrew the case.
Because who withdrew the case?
You've now gone to, according to what you said at the parliamentary committee, you've now gone to alternative dispute resolution. Rather than, so you've withdrawn the case.
No, the case is not withdrawn.
How can you both be in alternatively
the case is set down for October. So in the meantime, we're trying to find each other, and we believe very strongly that we find each other.
Why did you take the step?
Which one?
If the step for alternative dispute resolution. Number one, are you both saying...
You can't cherry pick.
No, hold on. Let me get to the question. The question is, why have you decided to embark on alternative dispute resolution when in previous weeks you were just pursuing the legal route?
You're going to allow me to answer the question.
Well, if you allow me to ask the question,
you ask them, I answer them.
Well, let's allow.
And don't allow me to. When I am in the middle of the question, you say, "I hear this," but you are doing the very same thing that all other people are doing.
I have a duty to try and get to the truth.
That's fine,
and
I'm going to give you the truth.
So why?
The truth is not what you want to hear, Sizwe, though.
The question. Do you remember the question?
Yes, I remember.
What was it?
Why are you now going through dispute resolution and I'm still explaining to you why we are where we are. And I'm saying to you, you then follow this process. IPSAS-B, which is International Public Sector Accounting Standards Board. The second one is the International Accounting Standards Board. IFRIS becomes the third and fourth, and so forth. Now, once you have got to that point, there is a standard available for social benefits in IPSAS-B. You don't have to go to IFRIS, because IFRIS does not have that standard. Now you stop there. That's what happened. We stopped there. We developed our accounting policy using that very same GRAP that allows us to do so. So that's what I'm telling you, that we then arrive at that point.
Disagrees with the way you define yourselves. So when you define yourselves as the social benefit organization, away from an insurance organization, that definition is exactly what is the question.
Who's defining us?
You are defining yourself. You're trying to define yourself away from being an insurer, which you've already said, towards a more social benefit organization, so that you can apply the standards that apply to social benefit organizations.
We can't define ourselves. In South Africa, it doesn't work.
Hold on. The question is, on what basis, then, did you depart from the alternative dispute resolution, the court process towards alternative dispute resolution?
No, but
one of the bases seems to be the way you define yourselves.
Let's not jump around. Let's be. I'm going to answer all your questions, but I think it's important that we structure this debate, because if we don't structure it, we are going to end up with everything bits and pieces, and the public won't understand that.
The question is very simple, sir. Why did you depart from the High Court route and go to alternative dispute resolution?
Let's understand.
Whichever way you want to answer that question.
Let's go to September. Let's go to September. But I want to come back to this after answering your question, because it can't be when I try to answer, then we go halfway, and then I am asked another question. Now, why did we go to dispute resolution? At the beginning, we asked that, guys, let's go through a dispute resolution mechanism. The dispute resolution mechanism is through the Office of the Accountant General. We did. The AG halfway through decided they don't want to be part of that. They then issued an opinion. We then said, stop, don't publish the opinion. Let's go again. Let's try to find each other again. They refused, which is why, reluctantly, we then went to court.
Okay.
Right.
Yeah.
Okay? So we go to court.
And you didn't want them to publish the findings
yes.
in court?
We go to court. Now, in court, they then say, no, they can go ahead and publish. We could not get it. Then we went, we said, let's appeal. We appealed, we got the leave to appeal. That's one aspect of things, which is what people are talking about that says, no, we withdrew something from the Supreme Court of Appeal.
Leave to appeal just means it will be heard. It doesn't mean...
And that's the point. That's the point. I'm saying that, but when you arrive at the leave to appeal, the judge says that the very same judge says another judge might find differently. That's why you would get the leave to appeal. But that's the point.
Sure, but it hasn't been...
Now, remember, at all material times, we are engaging with the AG. We are not saying we are not going to engage with you. We engage with them. Then in September last year, we issued this thing, papers are exchanged and everything. In September last year, we go in front of SCOPA. In going in front of SCOPA, we deal with this issue. SCOPA is unhappy about the fact that we went and took the AG to court. But in any event, Section 34 of the Constitution says everyone has got a right to access to the courts, where a matter can be resolved by application of law.
Yes, but
that's the point. Let me finish.
But hold on. Yeah. No one's disputing your right to go to court, but you don't have a right to victory. And if you lose, then you have a duty of accountability.
That's fine.
And so far, you haven't won.
If I win?
Yeah, then we will come back and we'll say it. But if you lose, as you've lost before...
If I lose, I'm telling you, I'm saying, when we went to, we said, we are prepared for sanction. That's what we said in front of that. In that very scope, we said we are prepared for sanction. Because we believe very strongly that what we did is right.
I heard that, and it was a very bold statement.
Yes, it was a bold statement because we know what we are doing.
But you still haven't come to my question, sir, which is, why did you go
I'm going there.
But can I ask you to go there soon?
No, I'm going there. In September, we then arrive. Remember, we are all going to court. We have filed our papers. The AG is going to file its papers, the answering affidavit at that time, and all those things that happened at that point. That's fine. We go in front of the SCOPA. SCOPA says they are unhappy and all that. The minister then says, maybe you are right. Maybe you are right, but the way you go about doing it is wrong, and therefore don't take the AG to court. He says this. He says, I'm instructing you guys to consider looking at other avenues, which includes, less confrontational means. That's how it was put. And we did exactly that. Okay? What do? We go there. We say, AG, the minister has instructed us this. The board takes a decision. We will withdraw, but these are the conditions. The condition is that we do what the minister says. We go into alternative peace resolution.
So you have withdrawn? Because you just said we will withdraw.
No. I'm saying to you, Sizwe, the decision of the board is the following. We will withdraw. The minister says consider. We say we will withdraw. Considering that if what the minister asks us to do can be done, which is going out to resolve, there is a dispute, it must be resolved by other alternative means. We write to the AG, we say, we are going to withdraw, but these are the conditions. The condition is that, one, it must be like this, and then they must be open. There are things that are put as conditions. But I'm saying, we then agree that we want to go through dispute resolution mechanism. Then this thing is not withdrawn, because what happens? The AG does not agree to go to a dispute resolution mechanism. So that's what I'm saying. That's how we land going out of court into this part where the decision is taken to say there is this thing of ability of withdrawing this thing from, provided this matter can be resolved through this process. And there's no problem with that, because we are saying we are quite comfortable, which is why in there we even say there is a known person that is a very good SC who deals with these matters of dispute all the time. We propose this person. Of course, the AG can propose whoever, but the point is, the minister instructed that we do that, and we did consider what the minister has said we must consider. So that's where we are.
Okay, that's where we are. We're going to come back to this very interesting conversation on questions of legal cases. We'll be back after this break, and we'll then discuss this question of the cost of various legal actions that have been taken. Stay tuned. Welcome back to Unfiltered. We're in discussion with the CEO of the Road Accident Fund. There was a fiery meeting at the Standing Committee on Public Accounts, and we're following up with some of the questions that were put to the fund surrounding the claims of people who've been involved in deeply distressful accidents and how they get their compensation. There are a number of questions from social media as well as some graphics that we'd like to show. So we're going to just put some context up for you so that you can get a sense of some of the statistics of the Road Accident Fund and just get a sense of the background and the sheer scale of the operations and the importance of this fund for victims of accidents and the importance to the fiscus. As we see these annual road crashes, the cost of accidents and the cost of motor vehicles, it's also important to try and bring some of your voices in from social media. So let's have a look at what you've been saying and some of the questions that you've been raising before we get back to our debate and conversation. So Gwena says, please ask him this question: why is he withholding innocent claimants' monies because of a lawyer's theft of monies from RAF? Some claimants' finalized matters have not been paid in more than 5 years because dodgy criminals called attorneys fraud with RAF. Let's take some other questions that are coming from social media and some other thoughts that are coming from Twitter. My mother was in an accident in 2011 and claims are carried by the lawyers. The Road Accident Fund officials took her from Limpopo to Gauteng for medical assessment twice. That was, if I'm not wrong, in 2017 and 2019, but so far no payments were made. And one final view, hi Sizwe, please ask what they have done to ban unscrupulous legal practitioners from doing work on RAF work, as well as whether there's been an audit of disbursement of funds versus what lands in claimants' accounts. Can you respond to some of those social media questions before we come back to our discussion? There's a talk of the legal profession and some of the fraudulent claims that are happening with the legal profession, but also just the lack of people actually getting access to their funds and the length of time it takes to get a successful claim through.
Yeah, it is this board and this management that is committed to pay claims within 120 days. We are the first ones to do that. Our predecessors had put 1,400 days and they still missed it. We are the first board to come and cut legal fees. The aim of cutting these legal fees was to make sure that the money goes to the claimant. We are the only ones in the past 3 years that have managed to take 30% back to the claimant. When we arrived at RAF, the liability, the short-term liability, meaning where claims had been concluded and the RAF did not have money to pay, was sitting at 19 billion rands. We are sitting today, when we closed the financial year, it was less than 10 billion. It was expected to be 51 billion at the end of that financial year. We have done a lot of work, and the issue is, when you then deal with these issues, the only part that people look at is this accounting policy treatment and all those things. The reality is that that's what we have to make. Now,
what about the victims and,
yes,
and the length of time that
yes,
it actually takes?
Yes.
Because that has been something even in your own reports you've been mentioning. When
we arrived there, Sizwe, the time it took to settle a claim on average was 5 years. You must remember that lawyers it takes about 3 years to claim, which is before it prescribes. So lawyers do actually go get the thing once you get injured immediately. They wait for 3 years. Towards the end of the 3 years, they come. They give us empty claims. 93% of all those claims that are at RAF that are in the backlog, you can't do anything with because they're just, some of them don't even have an accident report to show you the nexus. Now, we came and we said, give us minimum requirements. Every time you do that, they take you to court. You say, medical costs, we pay 5 times for any clinical procedure like any other medical aid would pay. When you say let's go and do our own medical tariffs, they take you to court. So that's what happens all the time. The reality is that this is a system where a lot of people benefited, and they want to say it's lawyers. It's not only lawyers, it's doctors, it's medical schemes these days, we have realized. it's hospitals, it's everyone that had a field day in RAF just pulling the money. Now, the duplicate issues that they talk about, we are the ones that found it. It's very interesting that it is this board that wrote to the minister and said, Minister, please ask the president to proclaim this thing. SIU must come investigate this thing. It is this board that asked for that. And the minister went to the president, and that's how this SIU came.
Okay,
and if you look at all those, those are the issues. So I'm saying we are reducing the number of, when we arrived there, people were owed 2,000 days. We are saying now, in 180 days, people have been paid once we have settled in 120
And
days.
what's the data for that? What's the evidence that it has actually improved since your tenure?
You see it with the reduction in what is called RNYP, requested but not yet paid, which I'm telling you was supposed to be 51 billion by the end of this year, which was about 9.7 billion when we ended the year. In previous year, it was also the same. What you are seeing is that we have stratified our liability. Instead of having 2,000 days, 30 days there, we have now set 0 to 30 until 180 days. And we have gone to court, by the way, committed ourselves in terms of the application we did in terms of Rule 45A to say every claim that is 180 days, we must pay within 180 days. Okay. And that's what we've been doing.
It's interesting that you say that, because in a recent judgment, you personally, the RAF and the board were castigated, that's the only way to put it, by the judge president and two other judges in a judgment which said your decision to fire panels of attorneys and have no plan in order to deal with the shortfall that would create caused what he called chaos, and actually mulcted you with a personal cost order where you are now, if that judgment stands, going to be personally liable for those costs. So that doesn't seem to square with your suggestion that you have come in, made claims better, made claims faster. If anything, that judgment is extremely down on your leadership and the RAF.
Those are facts. Why don't you go to the December judgment of the Supreme Court of Appeal? Why don't you go there? Because
hold
you see,
on.
No, but Caesar, let me answer.
No.
I'm gonna be no, but here I'm gonna answer.
No,
because I'm going to answer.
Answer the question.
I'm saying the Supreme Court of Appeal. Yes, Judge Logodi says that.
Sure.
The Supreme Court of Appeal, which is a higher court, says in doing what you did, which is we were sitting there with legal costs of 10.6 billion. We went in, we said, it is because of this part of us always going to court when we are not supposed to be going to court. We agreed that we are going to reduce this cost by 75%. And we are sitting at 75% as we speak. We gave ourselves 5 years, but we have reduced it by 75% now. It used to cost RAF every year 10.6 billion when we arrived. So today is 3 billion.
Let me get this straight. Yes. Treasury is wrong. Judge Logodi is wrong. The Auditor General is wrong.
But I mean, Treasury is wrong about
Parliament
what?
is wrong. Treasury is wrong about the fact that it's inappropriate to use the current accounting standard.
What has that got to do with the legal costs?
I'm saying that there seems to be a pattern in the leadership that no matter whether a court says something, whether another state institution says something, you refuse to accept that. And you continue on a different course. And the question still stands. Judge Logodi, in his judgment, Judge President, no less, says that your decision to fire panels of attorneys without an alternative led to chaos in the RAF and actually gave you personal costs. And how does that square with this notion that the RAF is on a new trajectory when the courts and Parliament are both saying
the courts are not saying that. I've just told you that the Supreme Court of Appeal went and said we did the right thing. You are choosing the Judge Logodi judgment because it suits the narrative. The Supreme Court of Appeal, which is higher than this Judge President you are referring to, has said that we are right. And it was on the 2nd of December last year. So I'm not understanding what you are saying. We have won all those cases. By the way, when we started this thing, the very same lawyers took us to court. We won. They asked for a section.
Judge Logodi released a judgment this year.
And I'm saying,
about the judgment
and I'm saying, and this is the part where that's why we're appealing it. Because we are saying...
No, but you can't say that judgment was overturned by higher court. There was a new judgment...
I've never said that.
That's what you just tried to assert. There was a new judgment this year.
I'm not saying
in January by Judge Logodi. And that you have tried to appeal that, but the status of that judgment is...
I'm not saying that. I'm not saying that. This is what I'm saying. I'm saying
clarify that.
When we started this process of getting rid of the panel of attorneys, which is when the contract ended, we didn't cancel it. When the contract ended, we said we are not renewing it. We are using what we call the state attorney model. And we are going to reduce cost by this much.
And Judge Lekhodi says
wait.
Hold on. Judge Lekhodi says that leads to some people in the Road Accident Fund having hundreds of cases to settle. They're overawed by the sheer number. And you didn't have an alternative plan for that.
Wait. I'm saying to you, we go to the court. We are taken to court. The argument is it's irrational, and therefore must be set aside. This is what the judges, the lawyers take us on and say. The very same thing Judge Lekhodi say. We go to the SCA. The SCA says, you're actually right. That's what I'm saying to you. Now, Judge Lekhodi comes in January and says what he says. We are saying, the SCA has said we are right. You are saying we are wrong. We are the ones that are saying, let's take this thing to the SCA again, because you are saying they are and in your own judgment, which comes after the judgment of the SCA, you don't mention that judgment of the SCA, because that judgment of the SCA takes or also has got a weight on it. So what I'm saying to you is that it is good to always, what people do when they try to paint a narrative is to take certain things. And then when they take those things and they say, oh, they say you're wrong, they say you're wrong, they say you're wrong, they say you're wrong, and therefore you're wrong. And I'm saying to you, we have followed the law at all material times. That's why the SCA agrees with us. Go and check the 2nd of December judgment. It's there for people to see. Now, because it does not suit the narrative, it's hidden somewhere, and people are saying this Judge Lekhodi thing. We have appealed it. So, in our appeal, go and look at our papers, what we are saying about this SCA.
What happens if you lose the alternative dispute resolution, or you change the accounting standard, or you go to court and you lose that? What happens if Judge Lekhodi's judgment stands? Will you then admit and accept, or will you take it even further to the Constitutional Court, as another case is now going that you recently lost at both levels? I guess the question is, when will you accept that you might be wrong on this?
On what?
Because the real point here is not about being right and wrong. It's about the fact that this ultimately is the taxpayers' money that's being used in these legal battles and these legal fights.
Which is I've saved the taxpayer 7 billion already.
You can't save on one hand and then
I've saved the taxpayer 7 billion.
On the other hand. The question is, on this question, it's the taxpayers' money.
I've saved the taxpayer 7 billion.
But you've lost.
You are willing to accept
far.
that? How much of that?
Well, let's see what happens. Let's see what happens in the Constitutional Court. Let's see what happens with the alternative dispute resolution. Let's see what happens with Judge Lekhodi's judgment. And the question on personal and tax liability. You have been given a personal cost order by Judge Lekhodi, which is very rare, and it's an attempt by the court to express its dissatisfaction with your conduct. Is that being funded? Is your defense there being funded by the RAF, or are you taking the cost personally for the legal defense of that appeal?
It says it's a personal cost order. I do that. But by the way,
so
when you take
are you paying?
No, this I'm not going to agree with. I'm not going to agree with it.
I don't understand why.
No, I'm not going to agree with it. No, I'm not going to agree with it. Let me tell you what I'm not going to agree with. I'm not going to agree with a point at which you are going to ask questions. I can't answer. By the time I try to answer, you are coming up with all these things, and then you are just fudging issues. So I'm not going to agree with that. Okay. Because you see, I came here, and when you called me here, you said we are going to discuss RAF matters. We have not discussed RAF matters. If I knew that we were going to come and discuss COPA, I wouldn't come here. Because I wanted to come here and give an account of what RAF has done. And that's what I must do. But now, when you are, you are not doing that. You are doing exactly what, you are doing exactly what in other platforms that have been done. You are calling it unfiltered. It's not unfiltered in the sense that when I'm trying to answer, you are not allowing me to answer. Okay. So allow me to answer. Yes, allow me to answer. Because you see,
cost.
Yes,
and whether you are
but I mean, that's not even a RAF issue.
No,
I said that in part. No, it's not.
It's a RAF issue because
it's my personal issue.
Well, it depends who's funding it.
Yes.
And your personal conduct was censured in your conduct as CEO of RAF. So you can't turn around and say it's a personal issue. It's both personal and it's RAF related because your conduct was as the CEO of RAF.
It's the money of my children that will be paid if at the end of the day I'm actually made to pay in.
And I appreciate that.
So you can't say to me that this, and this is why the part. I have appealed that, and this is how far I go. I have appealed that.
Are you
it's a personal cost order, yes.
Or is RAF
no, but I'm saying to you, I'm sitting here, it's a personal cost order. There are processes in any organization, by the way. When you take a decision, for instance, there's a thing called the director's liability and all those things. There is insurance that deals with those issues because you take decisions, by the way. So there's nothing that we have done at the RAF that is malafide. I'm telling you now. And I'm quite confident that we are going to win this thing with opener, because the reality is that there's nothing malafide we did. We went, and that's, as I'm telling you, the SCA has agreed with us. We are very comfortable that when we go there, we're going to win that case. Now, you are talking about the issue around another case that is also taken to the Constitutional Court. Here's what happens is, clandestine things are being done by people at RAF. Okay? Who are these people? In this case is medical schemes. Medical schemes, in terms of the Medical Schemes Act, are supposed to be paying your prescribed minimum benefits, and they should be paying your emergency medical conditions. In terms of Regulation 7 and 8, in terms of Regulation 8 of the Medical Schemes Act, they must pay all that money. What were they doing? They were going to SISU and say, you are a member, they will hire a lawyer, go and take this money, go and claim. We'll get a lawyer to claim for you. That money will come. Don't tell them anything. When the money comes, please give it to us. And I'm saying, SISU, if you knew you are a medical scheme and you're entitled to money that RAF was supposed to pay, why don't you just come in front and say, give me the money I've paid? Because they knew they can't do it. They do it in a clandestine way. We are saying they don't have reimbursement right over what is their statutory obligation. That's what we are saying. And we are saying, we think that's a constitutional matter, that at the end of the day, the judge, the higher court in this country must sit and look at it and say whether we are wrong in saying you cannot have a claim over or reimbursement rights over your statutory obligation, especially if we are a social benefit fund, as we say. That's the part. Let me answer this another question, SISU, you asked. What makes us a social benefit scheme? We have said it. Go and look at the Reserve Bank classification. We don't classify ourselves. Go and look at the classification of that is released by the, it's called the Institutional Sector Classifications Guide of 2017. 3.5, section 315 there, 3.1.5 will tell you there are 4 social security funds. One of them is the road accident fund. We don't determine that. It's determined at that level in 2016. It's already determined. So the thinking that we can sit here and say, today I decide I'm no longer an insurer, I'm a social benefit fund, is incorrect. And that's why we are saying, listen to us, go and look at whatever. When someone says to you, RAF is an insurance, say, give me the information on the basis of what is the authority you are relying on. And that's what we've been saying to people. Rely on authorities, rely on facts. When you are saying ASB disagreed with us, I can show you. There's a letter of the 1st of February 2021. There's a letter of the 23rd of August 2021 that comes from the very same ASB, even showing us this is how you apply this thing in descending order. Now, all these things, people are not willing to listen to. And all we are getting is all this noise that keeps on going ahead.
Can I ask you this then? Maybe you're fighting a noble fight against medical aid schemes, against law firms who are cashing in on the RAF. And you've actually fired, I think, something like 85 law firms, and you've spoken about how you think they've been milking the RAF in many ways. Interesting, okay. But then there needs to be an alternative plan once you fire those firms, so that you make sure that whatever new firms you bring in, or whether you're going to take it in-house, the capacity is there to ensure that these many, many claims are actually being taken care of.
Absolutely.
So I think the question then is, and what the Lekhodi judgment was getting at, whether right or wrong, is having fired that panel, was there an adequate plan? Because it seems like default judgments are just being given. There's not enough capacity to deal with the claims. And ultimately the victims are on the receiving end of this lack of capacity once you've got rid of this old system and old order.
So this is what happens. You arrive at that point and then you decide, I'm insourcing this. Now, your insourcing plan will depend on what is the capacity that you need? So you'd argue that what is it that I must do? Remember, now, when we started, we said there are 89 law firms. On average, maybe they are giving us 10 people each, which was not even the case, but let's just take an argument that is 10. So we say maybe you are spending 3.6 billion at the time on these law firms. Now you are saying, now if I sit here and I say I'm going to pay a lawyer, each one, I hire all of them, I hire 1,000, I pay 1 million each of them, I will then result in 1 billion worth of legal costs, or the cost that will cost me to insource this. And of course, you are going to add other things, but it will be much more less. Now, you then arrive at the point, you will then go to a Professor Henny Klopper's research. The research says 99.6% of all claims are settled at the doorstep of the court. Now you start to realize, but what do I need a lawyer for? Because if I need a lawyer, then I'm going to settle anyway, then I don't need a lawyer. Now, here's the part. We then say to them...
And I'm going to have to ask you to round off here.
Yes.
Yeah.
We're going to say to them, guys, we are going to do this, and we want to settle these claims, most of them. What then happens? These guys, at the time when they're supposed to give us the documents, the ones that were refusing with the documents, they refused to give us the files. Now you are sitting, you don't have a file. On the other side, the claimant has already claimed all these things are going to court. That's what happened. And if you go and read the Davis judgment, is the one that says, what will happen if you don't hand over those files? That's what will ensue, chaos. So Judge Davis oversaw this thing long before we could see it would come to fruition. Okay. So it is because they refused with those files when we said that bring those files.
Mr. Letswalo, that is still your name. Sizwe is still my name,
Absolutely.
I think. Thank you for answering the tough questions on Unfiltered.
Thank you.
It's always refreshing when a public official is agreed to answer those tough questions. Thank you for joining us. I know there were many tweets that we couldn't even get to because of this fiery conversation. Let's continue this conversation on social media. We learned much about Parliament, about the Road Accident Fund, about the citizens of this country and our public finances. See you on the next installment of Unfiltered, and have a good night.